What is it, 6:20? Yep. Under.
Do we have one?
Very first. 6:20.
It's fine.
Okay, let's turn our lights on. All right. I think we have enough to start. So, good evening, afternoon, evening. Welcome to the December regular meeting of the City Plan Commission. Let's do it is 4:47. We'll call the meeting to order. I'll go around and introduce ourselves. Attendance.
Will Sherry.
Dave Caldwell.
Charlotte Lipschitz. Alexa Thompson. Megan DeSanto, legal counsel.
Bob Azar, staff.
Leon Mandracar, DPD staff.
And Michael Gazdaco, I'm the chair. You all should have received the minutes from the November 19th meeting. A couple of you've had a chance to review them. If there are no edits or modifications, we take a motion to approve. Motion to approve. All right, we have a motion. Do we have a second?
Second.
All right, all in favor of approving the minutes from November 19th as drafted, say aye. Aye. Any opposed? Any abstentions? The minutes pass. You've also all received the calendar for the proposed 2025 City Plan Commission meeting schedule, the meeting dates and the filing deadlines. I'm noticing that there are a few that match with school breaks, so that's going to be tough for me, but you don't have school break yet, so you'll be fine. Anyone care to forward a motion to approve the meeting as drafted, meeting schedule as drafted? So moved. Okay. We have a second?
Second.
And all in favor of approving the 2025 meeting schedule and filing deadlines as drafted and circulated, say aye. Aye. Any opposed? Any abstentions? All right. We have a 2025 CBC meeting calendar. Next up, director's report. This is my favorite time of year.
Well, I hope it meets your expectations. We're going to talk very briefly about sort of the year in review. And Lev has just handed out some documents that show graphically and in a table format the projects that have been reviewed and approved through the year. So Lev, I'm going to let you go ahead and give us the quick overview.
Absolutely. Thank you, Bob. So a pretty decent, good year for development in Providence, both in terms of what was built and what was approved by the City Plan Commission. This is all information that's already on your sheets, but I will just go through it for the sake of the audience. This year, the City Plan Commission received 74 total cases, both including things that do and do not make it to the board for official public review. So that's including administrative subdivisions and certain categories of minors. 34 administrative subdivisions were received. More relevantly to you guys, 33 minors were received, both subdivision and land development projects. Of those, 9 made it to full CPC review. Every single one of which is UDR. That's the footprint of the state law change and the city's commensurate development regulation change that pushed some of these into administrative review. In addition, there were 6 minor LDPs, all of which that you reviewed, every one of which was received this year, except for one received in 2023. In addition, there were 6 major land development projects reviewed, a couple of UDRs in there. In addition to that, you also reviewed 23 city council referrals, 11 zones change requests, 7 ordinance text changes, including what's going before you today, and also 5 street abandonments. In addition, there was an IMP and a comprehensive plan public hearing, and 1 major change, that being to 279 Thayer. Throughout the entire year, in some form or another, either through a preliminary or a final plan approval, one of those 2 or a master, you guys made it to 382 residential dwelling units approved, a pretty good number. In addition, there were several non-residential projects that went through your review and received approvals, including 3 schools. In terms of the entirety of the city, our full development pipeline, there are 85 projects in there right now, including 3,775 total units. Of which of proposed commercial development. Of course, we'll see how many of these projects, sort of how they end up panning out, but that is our current pipeline. Besides that, if you, there are a couple maps included in your little packets as well. These maps represent this year, not what was approved by the CPC, but what was built in Providence, our total numbers of projects that made it all the way through the process and actually had an issued permit. This includes both things that received CPC review and things that went exclusively through the building department. Alexis would know quite a lot about a great many of these projects. There are two categories of maps here, one covering just this past year and one covering the span of 2015 to 2024. In this past year, the city issued permits for 576 new residential dwelling units in various forms and lost through either demo or renovation 24 units, bringing us to a total of 552 new dwelling units, somewhat above our average. Throughout the past 10 years, we've added a little under 5,000 new units and lost a little under 500 for a net total of around 4,500. So our total of 560 is a little bit above our norm. That is the state of residential development in Providence today. Thank you to the City Plan Commission for all of the units that you have reviewed and approved.
Thank you, Lev. That was great. Is that it for the director's report?
That's it.
All right, then we will go right into agenda item number one, which is city council referral number 3589, abandonment of Falmouth Street.
Is there anybody here for the applicant? Falmouth Street? It looks like we have someone online. Okay, so.
Raising hand.
All right, should I give an introduction?
Yeah, go ahead, Cheyenne.
All right, so thanks, commissioners. This is a request to abandon Falmouth Street. And as you will see, this is a street that lies right on the edge of Providence and North Providence. And the abutters, the owners of the subject lots, who are also the petitioners, are requesting to abandon the street as it lies between their lots. And so I guess we have the representative for the applicant, the petitioners, who can tell you more, and their intention is to merge the abandoned portion of the street with their respective lots.
Yes, can you hear me or?
Yes, we can.
Yes, I had a chance to meet with the neighbors out at the property.
Hang on one second. Can you start by stating your name and affiliation for the record, please?
It's attorney George Luff, Russo and Luff PC, on behalf of the Kasabian family, the Era family.
Thank you.
So basically the neighborhood had gotten together and they that street, Falmouth, has not been in use. In fact, if you go by the property, you'll see there's wood chips and then there's asphalt on a portion of it. And the parties just want to kind of revert that to a state of nature, as it is there.
So, Mr. Chair, members of the committee, this is a paper street. It hasn't been developed. There is a driveway that encroaches onto it that accesses one of these properties that actually is partly in North Providence and partly in Providence. The other two abutting properties are wholly within Providence, so it's the three abutters that are filing this petition. And if the council agrees to abandon this street, the area of Falmouth Street in Providence would be divided between the three property owners. There is this tiny little triangle in North Providence, and if they want North Providence to abandon that, they'd have to address that to the town. But this street, as you can see, is not built out. It's not being used by the public, and there are alternate ways to get between these streets without using it.
When I looked at it from like Google Street View, it looked like there were curb cuts heading into it from the Providence side on, what was that, Brentwood?
Yeah, there is
But
a
then
curb
there's
cut there, but
Big trees in the middle of it. It's completely undeveloped.
that's right.
Okay, commissioners, do you have anything for the applicant's attorney or representative? Okay,
These guys.
you'd hear the staff report?
Yeah,
All right, with that, we'll hear the staff report.
Sure, thanks, commissioners. And as you have seen, this is a paper street that's only useful to access the properties that it abuts. So we feel that abandoning it would not have an adverse impact on the public interest, given that it's only useful to accessing land that it abuts, we don't foresee a negative impact on future plans or existing land uses. As the petitioners are the owners of the lots abutting the property, we feel that they're all in agreement. No physical or legal access will be denied to other parts of the city, and they would need to grant any necessary easements. And they have provided a petition and plan as required. However, to that, we would like to add that they do need to provide an administrative subdivision so that the assessor can assess the value of the street, and this has to occur prior to them appearing before the city council. So based on that, we recommend that you make a positive recommendation to the Committee on Public Works, subject to these conditions, that the abutters come to an agreement on how the land will be abandoned, and indicate that on a survey that they will provide to the city. They should apply for an administrative subdivision to subdivide the abandoned portion of the street as described. And also, as was mentioned, this would only apply to the portion of the street that is within Providence, and will not apply to North Providence, and they will be required to grant any necessary easements.
Okay, thank you. Guess with that, we will open this up to public comment. If there's anyone in the virtual audience or here in person who wishes to speak on this matter, again, it's City Council Referral 3589. And seeing none, we'll close the public comment portion of this agenda item. This one's pretty straightforward, commissioners. It's a paper street, never been in use. I don't see any harm in selling it back to the abutters on either side. I would support a positive recommendation to the city council.
I'll make a motion to make a positive recommendation to the city council.
Second.
Just before we take it up with based on testimony and the recommendations in the staff report.
Yes, based on the testimony and the recommendations in the staff report. So you want me to go through them? Okay.
That's fine. All right, we have a first. Do you still second it?
Second, yeah.
All right, then we'll go around and do a voice vote. Noel. Oh, right, you just got here. Right. Will?
Aye.
Dave? Aye. Sid?
Aye.
Charlotte?
Aye.
Miguel?
Aye.
And I vote aye. All right. On to that, I think, we're moving into the second agenda item of this agenda, and we are seated, I think, for the first time this year as a full contingent of our city plan commission. We have all 7 members here this evening, which is, I think, a first. So thank you. I think, Bob, you're gonna take this one away. We're gonna do the comprehensive plan zone changes.
Yes, bear with me for just a minute. I'm going to bring up my presentation here. Okay, and I'm going to ask, all right, yeah, this is,
This has been a problem in other meetings where when it goes to full screen mode, it's not working. It was a problem last week.
Lev, what did you do?
I breathed on it, sorry.
okay, so I'm actually gonna. See, here's the other problem, is how do I stop sharing my screen?
So you will at the top of your screen.
Oh,
No, you're good.
Now you're
Stop sharing.
I was on the ads. My screen is still shared.
Oh, it is?
Yeah. Go into the share option.
I mean, I can just share it as a,
You can share that's.
do I share the screen or I can share the application?
Yeah, I think it's good.
Might change maybe Full Street Drive.
All right, tell me if the,
Got how it's appearing next to you here.
okay, so now if I go full screen slideshow,
That's what we're missing out.
Yeah.
Okay.
I think just share that screen. And it might do it. Cause it always ends up at that screen with your full screen.
okay.
But if that doesn't work, then. Not to go ahead and use text. That doesn't work.
I don't know how to get to,
Here,
yeah,
go to screen 2. Yeah,
screen 2,
yeah, press share, we'll see if this works.
okay,
Now go back to your,
presentation on screen
now
2.
do full screen, just full screen right from where you are. It worked, yeah, all right, we're in business.
All right, we're in business. Okay,
But you gotta pull up here.
yes, I've got, yeah, now how do I do that? How do I get it?
We can sit down.
How do I drag this onto?
I don't think we can, because that'll be showing Zoom.
Yeah, I think the best bet might just be to show this.
Yeah, maybe just show it in this format. What do you see right now?
Maybe how it's still paired to that
Okay.
screen, so you can go back to screen share.
Okay. And share the application. And we'll just do it small. I don't know how else to do it.
I think that's the other thing.
Sorry about this, folks, but this is the best we can do for the moment.
And you're
Okay.
seeing it, right?
Yeah, all right. Sorry for the small size of the display, but we'll do our best here. Okay, so what we're gonna talk about today is the zoning changes that we are proposing to implement policies of the comprehensive plan. And we have in discussions with the mayor and with the city council, we've decided that we're gonna advance this in 2 phases. Phase 1, we are proposing tonight, which is changes that are relatively straightforward, and where there's little ambiguity in the comprehensive plan about how to advance these changes. There's gonna be a future phase, and we're not gonna talk about those tonight, but just to remind you, the future phases are related to gas stations, design regulations, minimum parking regulations, student housing, industrial uses around the port, development incentives, and then inclusionary zoning. And I know that all of these things kind of fit together. The zoning ordinance kind of is you know, a lot of different interlocking rules and regulations, but we feel like it would just be too unwieldy and it would take too much time to do all of this at the same time. So that's why we're doing it in stages. So I'm gonna walk through these changes. This is gonna loosely follow the memo that I sent out with a table that's posted on our website that talks about the proposed changes in addition to the actual ordinance language. So you'll see part of the reason for the length of the ordinance is that there's a lot of deletions of regulations throughout here. So the R2 zone goes away. All the regulations related to R2 are deleted. Same thing for C1. And anything that was zone C1 that is now being zone C2. In the C2 zone, we made a couple of small adjustments. One is related to setbacks. Whereas the side and rear yard setbacks for C1 were 5 feet and 10 feet, and the side and rear setbacks for C2 were 10 feet and 20 feet. We've decided to make the side and rear setbacks for C2 both 10 feet. That way on a corner lot, it doesn't matter what you're calling your side or your rear, both will be 10 feet. We made slight adjustments to the uses within C2, notably, we're proposing to prohibit vehicle repair in C2, and to adjust the drive-through regulations in C2 to give the zoning board some authority to require more information about traffic impacts. We are deleting all regulations relating to the Capital Center District. And you'll see later that we're deleting the Capital Center Overlay District. Note that anything related to Capital Center also will require an amendment to state law, which we are proposing to be introduced into the next legislative session. Anything related to Capital Center won't take effect until both the city and the state act. We have language in here about allowing for the creation of small lots if there's documentation, official documentation that shows that there had been a previous lot configuration of substandard lots. We're going to talk a little bit more about that. We have some proposed refinement to that language. And by the way, we did get a handful of comments from the public, and we intend to address the ones at least that we were able to read before the meeting started tonight. So you'll see some proposed changes based on our further review and some of the public comment that came in. All right, this is something I think we're going to talk about for a little while. This is row houses. So just to give you an understanding of what we mean as we have amended the definition of row house. So I'm going to kind of walk through this in taking each of the phrases. So first of all, it's two or more dwelling units. First of all, it's a structure. That means, you know, the whole collection of units. We're calling this a row house dwelling. A row house dwelling can have two or more row house units, just like a three-family dwelling has three dwelling units. So it's a structure that has two or more dwelling units. The dwelling units are aligned horizontally, so they abut each other horizontally. They're separated by a party wall, and they're separated by lot lines at the party wall. So each row house unit sits on its own lot. And you can see that configuration here. This is an example in Providence on Bridgham Street, where each unit has its own lot and its own open space on the property. A row house is designed so that each unit has separate street-facing exterior entrance. Okay, so there's an entrance that's facing the street, and it has access to the front yard. And we say here a row house dwelling does not include a multifamily dwelling, because you have a multifamily dwelling is four or more units. Row house, the way we're defining it, is very specifically these individual single-family units that are on their own properties. They just happen to be attached to each other. A multifamily dwelling is four or more units on one piece of property. Okay, so if you have horizontally aligned attached units and they're not on separate lots, then we wouldn't call them row houses. We would call them a multifamily dwelling. Okay, if they're aligned sideways on the lot so that you can't get individual lots with frontage on the street, that's not a row house. Okay, so we're trying to be as specific as we can about what that means. All right, in terms of the dimensional requirements for row houses, the lot width would vary by zone. We say in the comprehensive plan that row houses should be at densities that are commensurate with other types of development in the zone. That when we talk about density, we're talking about lot area for every dwelling unit. So starting with lot width in the R1A, 37.5, the other residential zones, we're proposing 25. Based on some comments and based on some further review, I'm going to talk a little bit later about maybe adjusting that downward in the R3, R4, and RP zone to as low as perhaps 16 feet. Minimum lot size for each row house unit. This again is commensurate with the density that's allowed in the zone. So in R1A, we require 7,500 square feet for each lot, R1, 5,000. And then in the R3, R4, and RP, 1,667, which is a third of 5,000. So we took a typical minimum lot size of 5,000 square feet in the RP zone. We divided by 3, and that's the size of these lots that you can create. And we're saying that you can only complete the subdivision after the units are constructed, because what we don't want is for people to take a lot, subdivide it into tiny lots, and then not build row houses. This is only for row houses, and row houses, the way we envision it is that they would be built together, and that the end units would have side yard setbacks, and that the interior units would not have side yard setbacks because they're attached on both sides. Okay, and I'm gonna keep going, but I'm sure there will be some questions about this. All right, multifamily dwelling. We're proposing to allow for multifamily in R1A, R1, and R3 by special use permit. Again, this is called for in the comprehensive plan, and we're looking at densities that are a lot area per dwelling unit that are the same as what is allowed in the zone, with one exception, which is that if you preserve the building, we would allow for 1 extra unit. And then also another exception in the R3 zone, we would allow for a higher density if you can demonstrate that at least 20% of the units are affordable to households making 80% or less of area median income. There would be a maximum height of 3 stories. And then this provision here, if you have a lot of more than 20,000 square feet, if there are significant landscape or architectural features on the site that the owner intends to preserve through the special use permit process, the zoning board can make adjustments to setback and can allow for multiple structures on a site, and can allow for, what we call clustering of units, as long as the density stays the same. And then again, as the comp plan says, we would restrict these special use permits such that there are no short-term rentals and no more than 3 college students in each dwelling unit.
No matter the zone.
This would be in the R1A, R1, and R3.
But R4 and RP would still allow?
R4, you can already have R4 and RP, you can already have multifamily dwelling. And
I'm sorry, I'm speaking more about short-term rentals in college students.
college students, we are not proposing beyond this, we're not proposing to expand the college student rule.
Okay.
Which currently is in place only for single-family houses and single-family zones. We intend to have a further conversation about college students, but not with this round. And with respect to R4 and short-term rentals, we are also adding a provision that says that those buildings have to be owner occupied if they're going to have short-term rentals. Okay, and then in R4, we talked about this, that currently we don't have any density cap in R4, and we are proposing in both R4 and RP that there be a maximum lot area per dwelling unit of 700 square feet. So for example, on a 5,000 square foot lot, that would be 5 units. Keep also in mind that we have something called administrative modification that allows for administrative variances of 15%. And I apologize, 5,000 square foot lot, 700 square feet per unit. That's 7 units on a 5,000 square foot lot, plus an ADU, and with modification you could get up to 8 plus ADU. So that's the kind of density that we're talking about.
The ADU would also apply to
That's
row
the
houses,
max.
wouldn't it? Or
I'm sorry?
would the
Yes,
ADU would
yes,
also, so technically
correct.
you could get a two-family in a row house or a one family with
One
ADU.
plus ADU.
Right, so you
Yeah.
could, that would be like, in my mind, the only way you could have a short-term rental would be in the ADU of your single-family row house.
If it's owner
If
occupied.
it, as long
Yeah.
as it's owner
Yeah.
occupied.
Okay, so there are a couple of other miscellaneous text changes that we want to walk through with you. Some are related to compliance with state law and others are related to our use of this ordinance every day and finding loopholes, things that aren't clear and so forth. So I'm going to get some help from Megan and Alexis. Megan, our city solicitor, Alexis, our zoning official, to help with this. I think first, Megan, if you want to speak to the household definition in the state law that was recently passed.
Yes, thank you, commissioners. The city of Providence has for quite some time, as long as I can remember, regulated how many unrelated persons can live in a dwelling unit, and that rule has been no more than 3, which ordinance has been enabled by state statute. This last legislative session, the General Assembly amended the provision of state law that allows cities and towns to regulate the number of unrelated persons who can live together. And this they did by amending the definition of a household in the Zoning Enabling Act. Essentially, there's 2 definitions. One is a family and one is a group of unrelated persons living together. Admittedly, we really struggled with what exactly the General Assembly did with this amendment. It's seemingly unrelated to, other amendments they have passed this year and in 2023. And it's a little bit wonky. And after the state law was amended, arguably our current regulation was at least arguably invalid in some circumstances, what lawyers would call as applied. So we found it relatively confusing, but we did our best to comply and to develop an ordinance that is in spirit with what we already had, but is also in compliance with state law. If you want the specifics, the new state law defines a group of unrelated persons living together as it allows us to set a maximum number, but the maximum shall not be less than 1 person per bedroom and shall not exceed 5 unrelated persons per dwelling. So whereas the law before had essentially a minimum, the law now has a minimum and a maximum, albeit it's still discretionary on the part of a city or town whether they want to regulate unrelated persons in the first place. Our proposed ordinance regulates unrelated persons living together such that no more than 3 may occupy a dwelling unit with 3 or fewer bedrooms, and no more than 5 may occupy a dwelling unit with more than 3 bedrooms. We think this is in compliance with the state law. And if you have any questions, you can let me know. And I'll just say, we didn't want to forego regulating households in this way since we have for many, many years. So it's our effort to continue to regulate in keeping with our prior policy.
And this is separate from the regulation of students. We see that as a completely different type of regulation, and the courts seem to have recognized that, at least for the time being.
Also, the number 1 in section 201 is lifted straight from the state definition of household. I didn't like the language in that, and I was told that's exactly what the state has as for a family, which is interesting.
Right.
You know the number, the statute number?
Yeah, we have it here. It's at least the Senate side is Senate 2635, and it amends the definitions in the zoning enabling act, which are at 452431. All right, now we're going to go to Alexis to talk about some of these other issues.
My middle name miscellaneous. I think so.
Alexis, miscellaneous.
Good evening, commissioners. I'm gonna talk about the miscellany. So bullet number 2 here talks about the removal of special use permit references where there are no specific standards. If you all remember, earlier last year, in response to changes to statute, we went through the zoning ordinance and made sure that everywhere where there was an indication in the table of a special use permit, we had special use standards such that the zoning board had regulations to objectively use when they were reviewing such things. As it turns out, there are hidden special use references all over the place. So we have now rooted those out and added standards where we need to, or mostly removed. They were mostly not applicable to things that we see. So so that was sort of a continuation of a previous effort. Relative to rules of measurement, the front yard impervious surface, and so -1 there, and I'm gonna jump down to the bullet on the bottom of the screen, front yard encroachment for stairs. These both relate to a circumstance of the front porch and what does and doesn't work relative to the maximum 33% impervious coverage. The zoning ordinance allows for, if a porch extends the full width of a house, for the front of that porch to be considered the front face of the building, in which case that accessory structure, which is the attached porch, is not included in the 33%. If someone were to propose a porch that only went 2/3 or a half the distance of the front face, it is then not considered the front face, and it's within the front yard where we measure 33% impervious. And what I'll say is it just doesn't work. If you take that roofed area and add it to a standard driveway area, you end up over 33% majority of the time. So we're adjusting for the inconsistency between how we deal with front porches relative to that front yard impervious area by exempting just front porches from that provision. Somewhat similarly, stairs are within this category of things that are in the ordinance required to be 4 feet from any lot line. And as you, I'm sure, have seen all over the city of Providence, when you have a front porch in the front yard, it's very likely that your stairs could end up closer to your front lot line than that 4 feet. So all we've done is exempt stairs in the front yard from that minimum. Anything in the side, interior, corner side, or rear remain the same. So these are just sort of cleanup elements. And then, sorry, go back for 1 second, Bob. Sorry, the landlocked lots. I just want to touch upon
sorry.
that. Nope. So you all, I think, have seen some of this, and we are seeing a lot more. But the city has a lot of lots that are either landlocked within other lots, or they're landlocked between lots and a paper street. You just saw an example tonight at Falmouth Street. We have, do you have an example of this, Bob, or no?
I don't.
Okay, so what we're seeing when it comes to lots that perhaps only have frontage on a paper street is that often those paper streets are undesirable for development or very difficult to develop, and there becomes a question as to where the front of that lot should be. And so we are aligning the ordinance language with what we understand to be the kind of the most common scenario, which is that the front lot line of a landlocked lot be that lot line that you approach from the right of way, right? If you're driving through an easement driveway to a lot in the back, that lot line that separates your lot from that easement, how you get out and how you get in is really, the front is the front. That's what we're trying to do, is call the front. And I'm happy to answer more questions, and we can come up with some examples if we need to of that, but that's what that's about. Concrete block retaining walls. This picture is really quite illustrative, so hopefully I don't need to say much. There's a proliferation of proposals using blocks that are 2 by 2 by 4, 6, 8, enormous, in residential areas. I think part of this has to do with ledge and lots that are remaining are in areas where the topography is really quite steep. We've gotten a lot of feedback that they don't really feel residential in scale. And so there's a provision in the zoning, in these changes that, reflects a maximum size of retaining wall block, that is related to a standard and also engineered, block product that is not, highway scale. Bob, I think you had somebody referenced that these are often used to separate like giant mulch piles or giant rock piles in like,
Yeah, I've seen them in
storage
landscape yards
landscape
and
yards
stuff
and
like
storage
that.
yards, yeah.
That's what happens.
So, yeah.
Dirt, materials, mulch.
Yeah, we just feel that, they don't, they change the feel of residential development based on their scale, so, that is that, and are there any more there?
Oh, yeah.
Yeah, plenty more, okay,
Plenty more.
miscellaneous, my middle name, a long list. Refuse containers, are referring to dumpsters, so the issue we have is that the current zoning ordinance language didn't contemplate that 1, 2, and 3 family dwellings would require dumpsters. It only contemplated that they would be using regular, city issued trash and recycling totes. But we have seen a proliferation of those as well. So this just, sort of closes a gap whereby 1, 2, and 3 family houses are not exempt from the other rules, that relate to dumpsters, which includes, not being in the front yard and being enclosed, in a way that, well, we have that language in zoning ordinance, a full enclosure for a dumpster, and that they don't, that they can't be in the front yard. So that just takes out the exemption in a place that the ordinance didn't previously consider. Do you want to talk about curb cuts, Bob?
Yeah, so with respect to curb cuts. Well, I'm gonna talk about it, but in a minute, I'm gonna talk about how we're gonna recommend that this not be what it is. There was some confusion about our curb cut language and how it applied. And so we're proposing to clarify it. Suffice it to say that, first of all, we never see people looking for circular drives. And this is one of those that would have required a special use permit. So we just eliminated the language about circular drives. Lots in the RP district have its own special provision. We don't feel that's necessary. What we're talking about should be by the use, especially if it's in a residential zone. And then we wanted to clarify the language about when you can get more than one curb cut. Turns out that what we proposed is a little bit confusing. We also left out language about row houses. So in a minute, I'm going to give you some alternative language to this particular one. I'm going to turn it back to you, Alexa.
Great. Containing landscape materials is another of the mundane things, but a lot of landscaping material, if it's not properly contained, flows into the right of way. We see this a lot during construction where we do have rules in place for maintaining it during construction. The added language is just a little, it's some teeth for plan review purposes, such that curbing and maintaining a barrier such that landscape material does not flow into the right of way is required on a plan so that we can it will be easier for us to enforce that issue if we can maintain it on a plan. So that's pretty simple.
Okay, I'll keep going here. So we have, had language on our zoning ordinance about, the removal of a significant tree. We required a fine that was based on a recognized value of the tree. We got sued on this, several years ago, and the judge found that we weren't allowed to do that, so we're striking that language. And we're proposing alternative language, or replacement, when a significant tree is removed, either by the permission of the city forester or illegally removed. Understanding that the value of a significant tree, ecological value of the tree, is much more than the value of a small tree, even of a large species. We're proposing that the owner shall plant at least 3 large trees to replace it on the same property or in a location to be determined by the city forester. And we do have some data from the forester about the ecological benefits of say a 2.5 inch diameter tree just planted versus a 32-inch tree, and it's many multiples of benefit for the significant tree. So we think 3 is a conservative number, but it seems like an appropriate way to make up for the loss of a significant tree. Okay, zoning change petitions, sometimes applicants talk to us before they file them, sometimes they don't. When they don't, sometimes when we find out about it, we talk to the property owner and determine that it's not even necessary, or there might be some alternative to what they're proposing. So we are putting in language that would require a pre-application conference with the planning department prior to filing for a zoning change petition. This next one, non-conforming lot terminology. We use the term substandard lot and non-conforming lot synonymously, but the section 2003 is called non-conforming lot, so we want to just use that language throughout. That's all that is. And then finally, landscaping and pervious surface compliance. Again, this is one I'm going to talk in a minute about revising, but the idea here is we want to have clear standards about when you have non-conforming site conditions. This would be usually it's the amount of paving that's on a lot. It shouldn't come to anybody's surprise that many lots in residential zones are paved to a degree that's much more than what we allow. And we're looking for opportunities to correct those conditions as properties are being redeveloped. So we have rules about that, and I'll talk in just a minute about how we think that can be refined. Okay, and then there are map changes that we're proposing. The base zoning map is identical to what's in the comprehensive plan, except for one property. This is on 16 Borenquen. This is a property whose owner came to us relatively recently and also approached the councilwoman. This is an area that's very close. It's right on the edge of the Rhode Island Hospital campus. The owner would like to build multifamily on a small lot and would like not to provide parking. That property is currently in the MMU zone, which would require parking and which would make this project completely infeasible. I met with him and with the councilwoman, and she is in favor of this, so we're suggesting putting it in as a change to C2. Okay, and then next, the overlay map. There are a couple of changes in the historic district, and I spelled, no, did I spell? No, that's the right spelling. Sometimes things just don't look right. So in the historic district, there are 3 properties that we're proposing to add, all of which have the consent of the property owner, and then a couple which we are proposing to remove because due to either demolition or subdivision. There's no longer any historic resource on the property. We're including the removal of the Capital Center District. And that's it for the overlay zone. Okay, so now 2 more slides. I'm going to just talk about some refinements to this amendment that we would like to propose to you based on our further review and what we've heard. So row houses, R3, R4, RP. We think that our proposal of 25 feet of lot width is probably too wide. We've measured some row house units that exist in the city, and we see that it's not unusual to have something as small as 16 feet. So we would propose 16 feet for interior units and 22 for end units, which would allow for a 6-foot side yard for the end units. Okay, there was in the language about affordable housing, this was correctly pointed out to us that we talk about less than 80% of area median income. It should be less than or equal to 80% of area median income. That was a typo. Okay, 1407B. This is the curb cut language. We wanted to make sure that we have language in here for row houses, which we left out. We want to make it clear that each dwelling unit in a row house dwelling is permitted no more than 1 curb cut. So you can have a curb cut, but there can't be more than 1. And then 1407B3, I'll just give a little explanation here. The language about for multiple curb cuts, it used to say lots or uses in all other districts are limited to 1 curb cut per street frontage plus 1 additional curb cut for every 200 feet after the initial 200 feet. 200 feet's a lot, and we see some variances for this, and also it wasn't always clear if that meant you had to have 400 feet before you could get 2 curb cuts. So we wanted to rewrite this to say all other uses are limited to 1 curb cut per street frontage, full stop, and then additional curb cuts are permitted on a street frontage as long as there's at least 100 feet of street frontage for each curb cut. So what that means is that if you have 200 feet on a street frontage, you can get 2 curb cuts. So, large commercial lots, you need at least 200 feet. Okay, and then finally, on this slide anyway, this relates to this provision about lot merger, about creating small lots if it had been demonstrated that lots had been merged. We said that you can do this where it is documented, where the small lot configuration is documented in an official map or record of the tax assessor. We got a comment about this. It's, I think a valid comment. So we're suggesting that we use the terminology, an official plat book published by the city of Providence. These are, everybody knows exactly what an official plat book is. They go back in time. They are available. We have several of them in our department. They exist in the assessor's office, in the city archives. So that would be where you would find evidence of pre-existing lot configuration. Last slide. And this is the one that I'm going to have to blow up just a little bit. And this is again where we're talking about when you need to come into conformance with site elements. Again, site elements would be paving, landscaping, fencing, lighting. So just some of this is reorganizing. We're saying all non-conforming site elements shall be brought into conformance when the following occurs. And there's under 2 conditions. One is when a new principal structure is constructed. All right, you have a vacant lot that's fully paved and you build a new house, you got to tear up pavement and come into full compliance. If that lot doesn't have any landscaping, it's gotta be fully landscaped. If it's got a fence that's too tall, you have to make a fence compliant and so forth, okay? That's number one. Next is, the total area of building footprint, including principal and accessory structures, is increased by 30% or more. This originally just applied to an existing principal structure, but given that we are likely to see a lot more accessory structures built, especially for things like accessory dwelling units, we wanted to make sure that that additional footprint was captured here. So we don't necessarily want people to create outbuildings and just plunk them down in fully paved rear yards without addressing paving and landscaping, for example. Okay, next, we just changed some of the numbers here, and then there is a final provision here, number 5. When new construction of an accessory structure exceeding 100 square feet of building footprint, or when an accessory structure is converted to living space, all site elements in the yards where the construction or conversion takes place shall be brought into conformance. Example, you take a garage in a rear yard, the rear yard is 100% paved, you convert it to a home office or an accessory dwelling unit. You need to bring the rear yard into conformance with the landscaping and paving regulations. If you build an outbuilding that overlaps a side yard and a rear yard, you're required to bring that side and that rear yard into conformance. So that's what that is. And that concludes the presentation and the overview of the zoning changes. Happy to take any questions.
My first is even just on this one, number 5. I know that the comp plan speaks to reducing or eliminating where advisable parking minimums. I imagine we're going to be bringing that up in the next set of zoning, because a lot of this stuff, we're not going to get the density we're looking for unless we do that. Coming into conformance in a lot of these areas, I'm looking like an R3 zone where you need 3 parking spaces, 1 per dwelling unit, and an ADU, where you're going to find that on a 5,000 square foot lot that is already encumbered by a principal structure. We don't want people to demolish structures to create, impervious or pervious surface. There's a lot of chicken and egg things here, I think, but overall, I like the theme of it. I just think it's a halfway there. We still need to work through the rest of it, because a lot of these issues that we have, like row houses, lot area, things like that, I think a lot of them have encumbrances by having the parking that they currently have. And I think we need to keep that in mind for that next round. Obviously, these are the less contentious, quick wins to get aligned with the comprehensive plan. But I do think we need to keep working on the parking. A lot of these things we've talked about already, and I want to thank, we did have a couple of people from the public who sent in comment prior to the meeting. Like Joel Vanderweel, a lot of the stuff that you're talking about is talking about parking and things like that as well. I think these are things we're going to get to. But it's also the row houses we're addressing here. And then Dylan, thank you for your lengthy and annotated review of the text changes, because a lot of that has to do with the things that we've been talking about internally as well. I'm pretty good with the 16-foot and 22-foot width. I'm just still stuck on lot area for an R4. Because we have the same lot
area per dwelling
unit.
When it comes to row houses.
Because we have 1667, whereas the rest of the area in the universe of R4 is 700. So I just don't know how that jives. I think if we have 700 in R4, I mean, obviously there's more density allowed in an R4 than an R3. I think it makes more sense to have that aligned with the same regulation. We still have the width that's going to be maintained. So I don't know that you'll get much, but if you have, say, a 50-foot deep lot you could do, an 800 square foot lot that would work
Well,
at 16 feet.
and you don't.
16 by 50 would be 800 square feet.
Yeah. And the other thing is you don't need parking in
Right.
R4.
And you could do it where maybe, there aren't many examples of this, but there are lots that face two streets. And you could divide it down the middle and have one facing one side, one facing the other. And if we're looking for density, I think that makes sense. It's staying on the row houses, again, it's hard to create zoning when there's nothing here already, so we're kind of in a vacuum here. I completely agree with the lots being recorded once construction is complete or a certificate of occupancy is issued, which means they've met all of their requirements, but how can you get a curb cut approved without having that lot? And it's probably gonna be hard to get financing if you have nothing on paper that says you're going to get it, so maybe there's a method where it can be like a minor subdivision and then a final, where you get the first step approved, basically conditionally approved, and then your final recording of that subdivision is when you get a certificate of occupancy.
That's how we anticipate it.
Okay.
The language says subdivision into lots for individual row house dwelling units shall not be completed until the row house dwellings are constructed. So we would absolutely grant preliminary plan.
Perfect.
Conditioned on the row house units being developed.
Yep.
But, what we don't want to do is create a subdivision that never turns into row houses.
Yep. I think again, it's, we're looking at like section 2004, non-conforming site elements, C3 ADUs. We don't need parking there, but the other parts need parking, so I think what you've said here addresses a lot of that, so I'm appreciative of these changes. Those were the main ones I had, other than the text changes I'd like to see at the state level, but I'm not willing to make that argument. Not worth my time.
Right.
All right, commissioners, what else are your thoughts? I've had a lot of time to look at this.
I had some questions too about the row house. I think we're all excited about the opportunity to add more density and potential homeowner possibilities as well. But I did, so based on your description of a row house, they're all parallel to the street, front facing? Is that?
I'm
correct?
sorry,
No, no worries.
I was listening to somebody else. Could you?
No,
just
the description of the row houses, they all parallel, basically facing the street.
Yes.
So you can't, because you could have a multi-family townhouse complex where the houses might be perpendicular or.
That's right. Yeah.
Right, but we're not considering having like a row house type of opportunity where they could have, a real deep lot and potentially put in more housing.
The problem is that if the row houses don't have frontage on a street, it becomes awkward at best to create a subdivision where each of the units ends up on its own lot. So if you were to take these stacked units and turn them sideways, in order you'd have to create landlocked lots, and you'd have to create easements across every single one of them. And I think in a situation like that, if you're talking about home ownership, it's probably best to have a condominium.
Yeah, it's gonna be a multi-family unit
Right.
condominium.
Yeah, which is usually what they have in like. other
This
places.
is to make it easier
Yeah.
for, row house
And for,
construction.
and it helps for financing. Just wanted to clarify that, and then the curb cuts, that only becomes a nit or a concern, I guess, when they have some type of integrated, like I think of Westminster, I don't know, I think those are
Yeah.
condos right across the street from the diner where they.
Yes.
So they would need more, otherwise it'll probably be on the two end units going into like a back.
Yeah, so parking is gonna be hard for row houses. We anticipate that they could have front-loaded garages on the ground floor, which, depending on how you feel about it, may not be optimal. but one thing that does is it allows you not to pave your rear yard.
Right.
Yeah, there's an example of that on Westminster Street. They're like sunken garages.
right,
yeah.
Yeah, that's what I'm
That's
thinking
what-
about,
yeah.
okay.
Yeah.
Now, one thing that I think might come up is there's been concern about some of these new, there's single family right now, where they build those real high first floors to allow for a higher basement where you can have a nice big ADU, and basically it's a two-family.
Yeah,
Is there gonna be some type of, is there a design component to this where if just not something you didn't want to happen, where you can stop that from occurring, otherwise they could do the same thing, right? Build them, which is nice high porches that are at a second
Yeah.
floor level.
yeah,
And then they have an ADU that's probably as big, maybe even bigger than the townhouse, I mean, in the row house.
yeah. So a couple things on that. So first of all, the ADUs can't be bigger than the principal unit, but
Right.
but your point is taken that you know, these could be not just single family with another unit, but even two family. But when it comes to design, we agree that's, you know, something that we've seen proliferating. And this is a conversation that we've committed to having, but not at this phase. We're going to be establishing a committee that's going to help advise us on residential and commercial design standards. And we're, you know, in the beginning phases of putting together some ideas about, you know, what we want to see for design, but we expect that that's going to come in the next phase.
That group's probably also going to be advising on design bonuses, density bonuses, height bonuses,
Yes.
things like that.
Mhm.
In relation to it, but it all ties back to design.
And then one question and one comment, so I agree with, the chair was talking about the 700 square feet, but I was thinking about on the other side, what they call micro apartments, those are usually under 700 feet per dwelling, so how does that affect those? Are we
So we're
saying
talking about lot size.
It's, yeah, what we're talking
Oh.
about is the amount of land that you
That's
need.
required per
for-
dwelling
Yeah,
unit,
yeah,
got it. Okay.
we're not talking about the size. That's a
Got
good, it's a common misconception. I'm glad you brought it up because
Mm-hmm.
I should have been clear that we're not talking about the size of the dwelling units. We're talking about the amount of land that you need for every dwelling unit.
Thank you, and then I also agreed to and I think it was the same, the Joel's letter, I believe it was, that was talking about the 16 feet width that in the East
Yep.
Providence development that he just developed, and I think it makes sense that we
Yeah.
wanted to reduce that to make it more accommodating. for what we
I
want.
think 16 is good, and I understand the 22 on the sides is the 6-yard side, so I mean, that's always gonna be a larger.
Mhm.
I'm okay with that.
My question about that 16 feet is, has there been any study, and Bob, maybe the answer is no, or not yet, but of like most typical lots within the city of Providence, which I understand to be, you know, typically 50 by 100 and or 5,000 square feet, right? In those, unfortunately, the 16,
You get 3 and.
we kind of get slightly too wide to
Yeah.
get 3
Yeah.
units in those.
Right, yeah, if you're gonna have side yard setbacks, if you have a 50-foot wide lot and you're gonna have two side yards of 6 feet, that takes you down to 38 feet, which if divided in half is 19 feet.
It's 12 and a half feet per unit.
If you're gonna do 3.
If it were
Right.
3, it'd be 12 and a half feet per unit.
But I think, yeah, so basically we're combining it to 2 in that sort of typical lot.
Yeah, I think, yes, the answer is yes. And I will also say that we're running out of typical lots, you know.
Yeah.
Most of those lots are already developed. This is, there's no question that any development in the city is gonna be constrained by the availability of lots. Just
It's good
because
For corner lots, I guess.
it could be, it could be, sure, yeah, and, you know, our development community is creative.
Yeah.
So, we're providing, we're not necessarily saying that the tools we're providing are gonna be used at scale, but we wanna just try to reduce the impediments as much as we can.
Right.
Yeah, if we did, 18 and a half, 12 and a half, 18 and a half,
Yeah, 12 is tough for,
that would work on a 5,000 square foot lot, a normal 50 by 100 lot, which Bob's right, there's not many of those left either. They're all gonna be undersized that we're
And
looking
what's,
at.
yeah, I mean, yeah. I mean, that's tight.
Yeah, it is.
you gotta stare and.
Yeah.
Yeah, you're right. That's tight. Okay. Keep going around, Will. Dave?
My daughter's 12-foot apartment townhouse in Philly is 12 feet wide, very well designed and new. So I would just mention that if it's thoughtfully and well designed, aesthetically pleasing, a 12-foot row house is not bad. So I just would like that to know that, is there any flexibility, keeping 16, but if someone came up with a creative and thoughtfully well-designed type of project, is there any flexibility or what would be the administrative maneuver that they could possibly be encouraged to consider bringing that to the planning department?
Well,
Just an ask.
one thing to keep
How
in
much
mind,
is,
yeah,
What percentage is that?
15% reduction of 16 is 13.6.
Still doesn't get us there.
It doesn't get you to 12.
It gets us there for the outside, but not the inside unit.
If you take it 3 times, there's always different areas, but if you take.
Yeah, but
If you take
'Cause we only
85% times all 3 of them, that's the math we need to do. Give me one
can you use
second.
your microphone?
Yeah, because I wouldn't need to use all of it for the 18 and a half, but I need to use more than
It
that.
gets you to 51. Close. That would, sorry, what gets you to 51 is a 15% modification on all end units and an interior unit. So I was doing 85% of 22 and 22 and the 16.
What about 85% of the 6-foot side yard setback?
Oh, there's the one for John, see?
See, now you can make it.
And I'll continue to call row houses as much as possible, single-family attached dwellings. And just as, thank you for indulging me.
Which can each have an ADU. Just-
But with-
I feel like I need to keep reminding us all of
Yes,
that,
yes,
that
yes.
any row house dwelling unit, which is a single family detached, I think is an accurate description, can also have an ADU and become 2. So relative to density, just to keep that in mind.
So you're saying there's a chance. I like that. So we can do an administrative modification. We can get there.
Awesome.
Sid?
My question is about the tree preservation, significant tree. So one says that, you know, if you do it without permission of the city forester,
It's a violation.
right? And then 2, it says when it's removed, the property owner shall plant at least 3 large trees. Now, is that removed with permission or without permission?
Without.
That's either, when it's removed either with permission or
Or
without. And if it's removed without permission, it's a violation and there's a fine that attaches to a violation.
Per day.
So, right, but if you remove it
One
with,
day.
so if you remove it with permission, you still have to put in 3 large trees?
Correct.
So is there, I mean, I have a problem with that, only, you know where I live, very small lot on Bainbridge, and I did get permission to remove a significant tree, but there's just no way you could fit 3 more trees that size in my yard without taking up the entire yard.
Right.
Second is that a lot of the historic homes are dealing with, there's 3 on my street that had tree roots in their sewer. I just spent $4,500 redoing my whole sewer because of the roots from that tree. That's not why I took it down. I took it down because all the weather events last year and the tree had gotten so spindly that it was kind of hollowed out in the middle and was like a real threat to everybody else's house. But I do think that's a pretty big burden to put on people who have these small houses, these historic houses that were built. I mean, my tree was probably, yeah, I was sorry, I love that tree, but it was very old. It was huge. So, but clearly it was planted before, you know, my house is over 100 years old. So I just think we need to look at that more critically for someone with a smaller lot, because it's not really, I don't think that's very reasonable for 3 large trees.
Well, I
With
agree,
permission.
I agree with you that it may not fit on the lot. That's why we included a provision that said that they could be planted somewhere else with the permission of the city forester.
But I don't, yeah, okay.
And that's
So,
because the overall benefit of the significant tree to
right,
the outcomes of the city, the health and.
I definitely get what you're saying, and it is a real challenge. Like everything that we're doing, we're trying to find a balance between lots of really important public policies. Tree canopy, you know, again and again and again, we learn that there are benefits of tree canopy, especially in cities. And you can see drastic differences, for example, in the temperature in particular neighborhoods that have low canopy versus those that have high canopy. And we're losing our large trees, you know.
yeah, I'm not arguing that at all.
yeah.
I mean, like I said, I love the tree. It was a great noise barrier, everything else, but I'm also thinking of my neighbor who is in a similarly small lot and is in her, you know, 80s and has a big tree that also has to come down, and like, what's the burden on her to have to plant 3 more large trees to replace it with? I'm just wondering like where they're, how we deal with people who aren't just developers coming in chopping down big trees, but are homeowners who have his old houses that the tree is as old as the house and that was planted, you know, in horse and carriages. And how are we not putting a huge burden on the homeowner who may be elderly, fixing from whatever, to deal with this?
I'm not gonna disagree with you that it is a burden. There are lots of burdens on homeowners. And, you know, I mean, like I said, you know, the value of a significant tree, you know, outweighs so first of all, let's, are you suggesting that there should be a difference in what we require for replacement between someone who's violating the ordinance by brazenly removing a protected tree versus someone who goes through the process and gets permission?
Yes, and, you know, so I mean, and if there was just like more, if there were just an easier glide path for, okay, obviously you're not gonna replant on this tiny lot, but who, like, the onus is on who to find where the 3 trees go, or like, how much is it, or is it, are we planting a sapling that's like $2.50, or is it like a already, you know what I mean? Like, I just think there's a lot of more questions here, and I wonder if there would be wiggle, you know, I have questions
Yeah.
about the implementation. Is it like, okay, so you have to buy 3 trees and we're gonna plant them in a park, but is it cheap saplings, or is it halfway mature trees? Like, a tree can vary in price depending on how old it is and what you're replanting. So I'm just,
Yep.
and I would hate to just kind of leave it up to interpretation of whoever's answering the phone.
We do
to
have
say-
planting specifications in the ordinance.
Okay,
I can't remember what, I think it's like a minimum of 2.5 inches.
It's a 2.5-inch caliper.
Caliper.
I'm checking on that.
okay.
Yeah, so
Yeah,
I
but
mean,
that's all I wanna know, is
Yeah.
that if is it gonna wind up being this like big burden for like an elderly person who has to take the tree down because it threw in their sewer, and then is she, you know, how much is she gonna have to pay to, that's all.
yeah. Okay,
It's a 2-inch caliper at planting.
Okay.
yeah. I think, you know, I think you're talking about, I don't know what the cost of a large tree is these days, but, you know, I think, you know, there's certainly something that could be in the hundreds of dollars. It's not gonna be it's gonna, I believe it will pale in comparison to what it costs to take the tree down.
Well, that's what I mean. So if you're like my neighbor who, you know,
Yeah.
it's 1,500 to take the tree down and then hundreds, and you're on a fixed income and it's just not. So I just want to make sure that we're
Yeah.
not overburdening. I mean, I get it that I just think there should be two separate lanes.
Okay. Council, do you have any comments on this?
do. I agree that the ordinance could be refined a little bit to avoid some vagueness. Particularly what is 3 large trees? It sounds like it would be 3 trees that will mature into large trees.
Yeah, the ordinance defines what a large tree is.
Okay.
Yeah.
And I don't know, I think shall plant sort of sounds like the property owner has to get out there with a shovel, versus maybe shall, I don't know how we can refine it, but I know that the city has a tree planting program.
Yeah,
where-
they work with the city forester to find there's language that talks about that in the zoning ordinance, whereas if you can't plant it on your own property, work with city forester to find acceptable plantings or pay into the tree fund, I believe.
Right, yes. As council, I'm a little concerned about the similar treatment that you had with a violator versus a person who, through no fault of their own, has a unhealthy or unsafe tree. I also know we have a lot of benefits from tree canopy. I didn't know if it's something that we could address with a ratio, a different ratio, like a 1-to-1 in the case of a non-violation, and a 1-to-3 in the case of a violation. I don't know if it particularly matters, but I do know one replacement tree is woefully undervalued compared to the benefits of the significant tree that was removed, but my concerns as council are more related to the validity of the provision. It will be an interesting exercise to see, because it is creative.
Well, one thing I have to say is that the forester can give permission to remove a significant tree if it impedes economic benefit of the land. So that's also not for an unhealthy tree that needs to come down, because we saw it on a lot that looked to be subdivided and have 2 separate parcels and built houses. There was a tree that needed to be removed. The previous city forester denied that. The new city forester allowed them to do it. Now they're taking the tree down and they're subdividing it, but that's with permission. So I want 3 trees for that tree because
Same.
they're putting, so it's hard to define.
But couldn't there be 3 sort of tranches here? One is a person who doesn't violating the ordinance.
Absolutely.
One is, we want to take this tree down because we want to
For
develop the
redevelopment.
land in a different way. And the third could be the onus is on the owner to provide proof of either, safety concerns or I don't know.
The city forester's discretion.
Well, I mean, one way to do this is, yeah, I think you might be onto something, Charlotte, because, if the tree is diseased and it's gonna die, then eventually it's not gonna have any benefit.
Right.
So.
And it's gonna have a lot of downside.
Detrimental, right, it's gonna be an economic.
So maybe it's actually 2. One is if either, so one is, maybe it's a 1-for-1 replacement if the forester determines that it's dead or dying, or a safety hazard. And then it's 3-for-1 if either no permission or permission because the applicant wants to develop the property.
Yeah, I think,
I
because
would support that.
again, I like that, because again, I'm thinking just in terms of the tree I had to take down. It was 4,500 to replace my sewer line because of the roots, and then it was 1,500 to take the tree down, 400 to grind this down. So, okay, like and now I gotta pay another 500 for the 3 replacement. It just adds up, and insurance doesn't cover it, so that's a lot of money for someone to pay out of pocket.
Yep.
And I'm thinking about my neighbor who's about to go through the same thing, and she's 80 on a fixed income. So I just would hate to add that additional burden of even $300 more dollars for the tree, but. that's-
Okay, so I think that, I think
I like that.
if that makes sense,
I like that.
we'll accept that as an amendment.
And what's a significant tree? That's based on the foresters.
Yeah.
They have a criteria of what they consider a significant tree. What if someone takes, because if the intention is tree canopy, what happens to those trees that don't qualify for significant, but it's still significant? Like I took, one fell, and then it made the other one put it at risk, and they took it down. I happened to plant more trees because I had the area to do that, but I'm thinking they weren't considered significant trees per the forester, so I wouldn't have to plant some, but if we're trying to make sure we maintain the canopy and increase it, it should also fall in.
Right, so we already say that there's a minimum amount of tree canopy that is required for every piece of property, and if something happens where you go down below that canopy, you're supposed to plant trees to replace it.
Right.
And then with respect to a significant tree is defined as 32 inches in diameter when measured at 4.5 feet above the ground. And, you know, maybe it's an artificial distinction, but, you know, it was one that we arrived at. And I think it's a best practice that, you know, once a tree gets to that size, it has, you know, outsized value. So that's the distinction. Below that, we just consider it a large tree. We assign it 1,000 square feet of canopy, and if it goes away, it takes you below the requirement for your property, you're supposed to plant either a tree to replace it or other kinds of trees that get you back up to that canopy.
But that's if it goes, so.
If it goes below.
But if you're above it, it's still.
Then you wouldn't have to.
Right, you wouldn't have to, but we're still losing that canopy
Yeah,
for that particular neighborhood.
Which we acknowledge.
Like if we're working with the tree cutting companies, it's like, well, for every tree you cut at a certain size, or you cut period. If I had to hire you to come cut the tree, it's probably having some type of benefit where there should be some type of
There's also,
replacement.
you know, that section 2004 and the non-conforming site elements is also speaks to that, is if you're low on canopy coverage, there's a mechanism to enforce that also.
If you're low, yeah.
You know, but you're right,
Yeah,
there
but if
could
you're
be
under-
some
but if you-
trees that
yeah,
come
but if-
down that are above the canopy coverage requirements.
And
that's
therefore
really-
you don't have to.
That's all we can really enforce on. You have to have a standard.
Yep. Okay. Fair enough.
Anything else? I'm gonna propose we take a 5-minute break before we open up public comment, just to use the restroom. But anything else before we do that?
There's a maximum allowable size for a residential zone, 12 feet.
I'm gonna ask for Alexis's help here. So, curb cuts, we don't regulate the width of the curb cut, we regulate the width of the driveway. And so you can, and Alexis, do you wanna add to that?
I'll only add to it to say that it's actually somewhat helpful that that the zoning ordinance doesn't regulate the width of the curb cut, because there are certain circumstances, and this will likely not be the case for row houses, but where if DPW is okay with granting a wider curb cut, a parking area maybe is 2 or 3 cars side by side directly off the street, and that could have the effect of reducing further impervious coverage on the lot. So sometimes it's a positive circumstance, or it's literally just where things fit. So the flexibility to have a wider curb cut for a parking area versus a wider curb cut for a driveway, which are 2 different things, has been helpful in my experience.
So my limited experience in building is, you can't get more than 12 feet on the curb cut opening at DPW.
They do grant they do grant widths that are greater than 12 feet, depending on the plan. I have seen them. Perhaps it depends on the lot you're looking at or the configuration of the project, but they do. We can speak specifically about the proposal as you've seen, but I have seen permission granted for wider curb
And that,
cuts.
but that comes from DPW,
Correct,
not from.
yeah. Because it relates to, I think, traffic and other concerns in the right of way. So anyhow, there has been, good flexibility from a zoning perspective to not regulate the width of curb cuts.
I propose we take a 5-minute recess, for restroom break at 6:18, so we'll come back at 6:23. Okay, let's take our seats.
Yeah.
Lots of decisions.
Okay, at this time, we will open this up to public comment. Let's keep it focused on the zoning changes that we're proposing here. Not just as drafted, but as modified, because that's what we're currently discussing as well. So if you would like to speak on this and you're visiting us from the virtual world, please raise your virtual hand by pressing *9 if you're calling in, or your virtual hand in the bottom middle portion of your screen. And if you're here and you'd like to say anything, we'll start with the people in the room here today. Raise your hand and come forward. We have some representatives from the city council. Let's start with them. You sure?
Yeah.
Okay. No comment. That's great. Do we have a sign-in sheet with anyone? It's empty, so then we'll just start by calling people up. Go ahead.
Didn't know there was a sign-in.
Oh, it's quite all right. Yeah, right over to the microphone here, so that everyone, even watching this from afar, can hear what you have to say.
Great, thank you. My name is Dylan Giles. I'm an organizer with the Providence Streets Coalition, and I've written my remarks just to keep them as short and concise as possible.
Thank you.
So at this Providence Streets Coalition, we've been organizing around the comp plan for many months, and we're very grateful to the city's planning staff for listening to the voices of all of the community for the last 2 years. As we have from our inception, the Streets Coalition has been advocating for policies that make it safer and easier to move around the city without a car. So we're supportive of the changes, specifically the increased zoning density for all residential zones. These are a crucial tool toward achieving that mobility goal due to the interconnectedness between housing and transportation. Policies that allow for increased and broader density will make it easier for people to live closer to the places that they need to go: jobs, services, restaurants, public transit, events, shows, all of the things that Providence already has. And while the residential density increases are critical to reducing the housing crisis Providence is facing, as the chair rightly pointed out earlier, these efforts are hamstrung by the continued requirement of one-to-one parking minimums. We look forward to continuing our efforts to relieve the burden on housing production by advocating for the widespread reduction of parking minimums. I know that this is going to be a topic of a future meeting, and I look forward to that meeting where those recommendations will be discussed. I'd also like to support the significant tree replacement requirement. The urban tree canopy is a valuable asset to the quality of life and in the city, and removing precious shade has a significant impact in the urban heat island effect that is growing worse as climate change makes our temperatures warmer. And finally, I'm glad to see further restrictions on drive-throughs. Requiring a traffic study is a step in the right direction that existing drive-throughs should have to go through, I think. But it's also not clear to me how the adverse impacts of vehicular traffic will be determined. To me, a business like a drive-through that encourages an increase in unnecessary car trips, in addition to causing cars to queue and idle, should be considered adverse and out of character for how we envision the city's future. I hope the CBC will think very skeptically about allowing any future new drive-throughs in the future. These auto-oriented uses are antithetical to the goals in the comp plan of reducing car dependency and creating a more vibrant and walkable, people-friendly city. Thank you very much.
Thank you. Thank you for having your comments so well organized. Appreciate it. Dylan, you're the next on the list. Come on up. You got in there and signed up as soon as you knew there was a sign-up sheet.
Thank you, Mr. Chairman. Thank you to all the members on the board, to the staff. I think this is incredible work. I think for a moment to just look, if a client had asked me 2 years ago whether about half of these things were politically viable, I would refuse to take their money. Like I said, no, I won't even bother to ask. So the amount that the Overton window has moved in Rhode Island is phenomenal. And I think Providence is playing a leadership role in that. And I'm very thankful to all of you for doing that. I think a lot of the amendments that were presented this evening are also fantastic. I think the we kind of got to a space on the row house width, that I don't want to push for anything different than what's already discussed. But I think maybe for the benefit of the public and a little bit of the discussion around why 12 feet actually works well, is when people conceive of the width of a home, they're usually conceiving of the width of a space that contains more than one set of rooms. But a row house is a single set of rooms. A 12-foot wide room is not a small room. That's a very healthy room. So if you kind of conceive of a row house not as a house, but sort of a stacked single set of rooms, that 12 feet, I think, starts to breathe a little bit in your mind. You know, if you've been in a 12 by 16-foot room, that's a nice room. That's my living room. That's exactly how my kitchen is set up. So I think that space is great. When we talk about how we find the right level of density per lot, I think with row houses, because you're getting one dwelling unit, it's essentially a single family home, right? On each lot, your density just isn't going to skyrocket. And I think you want to be able to get the same exact amount of density that you could with a multifamily. Otherwise, what will happen is the multifamilies will be built and the row houses will not. I think that's unfortunate for two reasons. The first reason is the American tradition of home ownership has been essential to generational wealth building. And I think that's a really key component of planning in America. And I think single family attached homes are a way to expand that opportunity to more people today. And then secondly, if you ask someone living next to a 5,000 square foot vacant lot, if you would rather their neighbor build a 3-family house or 3 row houses, I think they're going to want the 3 row houses. I think people like living next to more homeowners, people that are similar to them. I think it represents an investment in the neighborhood. So I think when you have a scenario where there's more allowable density for multifamily than there is for row houses, you're basically, even though it's not a requirement, you're creating an economic requirement that people build multifamily. So the density per lot, if we want to drive row houses, should be equivalent to the density per lot on multifamily. I think an easy way to deal with that is if you take a lot as is, you can create a buildable box, this sort of concept of what is the maximum building that I could build in that space. And then if you say the maximum width or the minimum width of a row house is 16 feet, you take that box and you chop it up. You don't really need to do anything more complicated about figuring out how many dwelling units per square foot. You just allow the buildable box to be chopped up and then you're done. I think that's the simplest way to do it. And I think it allows for creativity. There's a couple spots in the regulations where there's a shall clause. I would recommend changing some of those shall clauses on design to shall make all reasonable efforts to. I think that does 2 things. One, it puts the DPD in the driver's seat about whether or not all reasonable efforts are actually made to meet that performance criteria. And secondarily, it avoids the need for variances when there's an atypical lot problem. Now, I'll probably lose like 10% of my cases a year because of that, but that might make everyone else happy. So the other question I have about the row houses, and forgive me if this was dealt with a little bit, a lot of us were trying to keep up with the discussed changes while they were coming out. What are we doing about front yard impervious if there's a parking requirement? Because if basically the whole thing has to be paved, I know there was a discussion about front yard impervious. Did we address that at all on how it would work for row houses?
Yeah, for row houses, we increase it to up to 50% impervious in the front yard.
Okay.
Now that was when we were talking about 25 feet of row house width. So that makes it challenging. I think that might have you know, as we think back about, you know, the decisions that we were making through this process. I think that was part of the calculus that the front yard would, you know, for narrow lots, if you're gonna accommodate a vehicle, you need at least 8.5, 9 feet for a driveway. There's gonna be a limit to how wide that lot can get before you're over even 50% impervious. So it's a question that, you know, we should be asking ourselves, is that what we want? Is, you know,
No, we don't.
front yards that are 100% paved, front yards that are all parking, nothing but driveway access to, you know, a integral garage. That's challenging.
That is.
I think it's challenging when paired with the off-street parking requirement.
That's we go back to the same problem I said, which is the parking is driving all of these design requirements, and we really need to get to that parking to really fix all of this.
That could be a space where shall make all reasonable efforts to be at least 50% impervious. Is I mean, it'll happen wherever it can.
That's not specific and objective.
Fair enough.
I don't think that would pass, so I think we get sued, and it would be very.
If it's not a special use permit, but on the lot, I don't know what the substandard lot recreation. Just a question in practice. If there's, say, a parking lot that another building is reliant upon, what is the impact on that? Because there is the language in there that says shall comply with all other subdivision regulations. So there are backyards, which are now parking lots, which could become buildable lots. But then the existing structure no longer has any ability to park.
That's kind of exactly what I said.
Yeah, we thought about that. That might be a candidate for a variance.
Okay.
Or from parking regulations, for example.
I think the last thing that I want to spend time on, or at least kind of propose to you all, in my submission, I walked through how I got to a density in R4 and RP, which is, instead of 700 square feet, is 333 square feet. It's derivative of the building code, so I think it makes a particularly efficient build. 3 stories of 4 units in each story. So I think that deliverable makes a lot of sense to me. The other thing that I will say on that front, if a consideration on that change in density, which in R4 and RP is a significant reduction, the time frame for when that would occur, whether, and maybe that's different for lots that are about to become R4 versus some pre-existing R4 lots, but as just a fact pattern, over the course of the weekend when we came across this, I reached out to my clients to give them a heads up. I have one client that is purchasing 2 R4 lots right now. He's under agreement to purchase them at a price valuation based on no limit of units per square foot. But by the time he closes, there will likely be a 700 unit per square foot limitation. So in that space, if there was maybe a couple months where this law shall take effect in February, as opposed to January on those R4s, otherwise you're going to see a whole lot of applications from me that aren't really high quality within the next 14 days. That's what's going to happen.
Well, that sounds like a threat.
I feel bad about it. I mean, I don't know. I don't want to.
And you know what we do with low quality applications.
Yes, I've been through that ringer. So that is a consideration. I think, you get to 333 square feet, that's derivative of the building code. I think it's economically viable. I think that's particularly important in second tier neighborhoods, where the end result on rent per square foot is maybe lower than what you want it to be without additional density. And I don't think it makes a meaningful change because you're still going to cap out at about 12 units. And I don't think that's a big building. So I'm happy to answer any questions, but largely I want to be thankful. really appreciate everything that went into this.
Thank you, Dylan. Appreciate it.
I'd also like to ease any concerns on the part of this commission that the law is such that legislation only applies prospectively unless it expressly states that it applies retroactively. And so no one has rights to legislation to be applied retroactively unless the legislation so states, let alone rights to legislation that has not yet passed.
And this is gonna take at least 2 city council here. It's gonna take ordinance committee twice and then 1 full city council.
It's gonna take a month of advertising. It's gonna take a public hearing, at least 1 session of public hearing at the council, and then two passages. So mechanically, you're looking at 3 months from the first of the year, basically. Best case.
In all reality. Okay. All right, next individual here in the room, raise your hand. Anyone else? Mr. Bulgarian? We'll bring you the mic, sir.
I can get there.
Try to run.
Tryon needs the steps in.
Oh, I don't think so. It was pretty good.
I could see them.
I will stand, excuse me, if you don't mind. Grant Bulgarian, 20 Extra Street in Providence. First, 2 things. That's all for right now. First, I want to commend the department for recognizing that we need minimum square footage per dwelling unit in R4. They eliminated it a year or so ago when they bundled it in with what they called a bunch of technical amendments, and I was against it then. And so now it seems like that they've decided they're going to rectify that and put in minimum per dwelling unit. I would suggest it needs to be more than what they're proposing, not less. So that's number 1. Number 2, you know that I am so vehemently opposed to obliterating R2 zones citywide. I think that's totally irresponsible, not worthy of the talent that we have in the planning department. And so I want you all to reconsider. And why do I say that? Because I grew up on the 2nd floor of a 3-family house in an R2 zone. It was a mixture of single, 2-family, 3-family homes, and we were crowded. We didn't have a place to play. Played in the streets, broke my share of windows, repaired every one. But why did Providence lose population after World War II? Because most urban areas in the United States lost population after World War II. Why? Because families were forming and they wanted to have a little elbow room for their kids. Between 1950, up for the first half of the 20th century, Providence was a city of 250,000 people. 1950 census, 248,000 and change. Between 1950 and 1980, Providence lost 5%, 10%, 15%, 20%, 40% of its population. Providence lost. Now, a lot of urban areas lost population, but not 40%. Why did we lose that? There are a number of reasons. I'll leave it to you guys to learn why we lost it. My suggestion, my recommendation to the department, to the City Planning Commission, to the council, was look at the numbers. 2 sets of numbers. Population numbers and dwelling unit numbers, or as the census calls it, household numbers. And when do you look at them? As far as Providence is concerned, 1950, 1980, and 2020. We have less than 4 dozen census tracts in the city of Providence. Look at it, look at the numbers by census tract. They don't, census tract, the tracts don't change. Ward lines change, rep lines change, senate lines change. Census tracts don't change. So they're consistent throughout that entire stretch of time. Look at the numbers. That will inform us where we lost the massive population and where we should focus our talent and our abilities and target where we want to replenish the population, not just obliterate R2 zone citywide. That's irresponsible. And if that's the direction that planning is going, I'm very disappointed. I'd be interested in knowing what the other 38 cities and towns are doing with their two-family zones. Are we in the vanguard of obliterating R2 zones in the state of Rhode Island? Anyway, that's my request, is for reconsideration on part of the City Plan Commission, based on the numbers. Look at the numbers. Tell the department, get the numbers, then everybody can look at them. I'm a firm believer, the more information we have, better decisions we make. So that's my request. Thank you very much.
Thank you. Anyone else here in the room who wishes to comment on these proposed zoning changes? We do have people at home, or sorry, you don't necessarily have to be at home. You're in our virtual world. Let's start with the first one, Dustin DeZubi.
Thank you very
Dustin,
much.
there you go.
This is really great. It's exciting to see all of these changes. So I have a couple questions just on clarity. So for the new lots that would be created for the row houses, for something, for example, in like R1, does the new lot size have to be 5,000 square feet? Because if the width is 25 feet, that would imply a depth of 200 feet, which is an atypical case. I was wondering if the intent was to have two row houses on one 5,000 square foot lot, or if it was to have one row house instead of a single family on a 5,000 square foot lot.
Yeah, so it's the latter. It's essentially taking what you could do on two 5,000 square foot lots and joining the houses at the lot line. Otherwise, we would be doubling the density of that zone, and that's not what we committed to in the comprehensive plan.
Got it. I appreciate the clarity on that. My next question was just, I guess, I think Dylan touched upon it. These substandard lots that have been merged, if they're recreated, it's not just parking, but it could be impervious requirements that are going to be negatively impacted on the other part of the land. If the backyard's being split off, the ratios could change. Is that something that's going to be considered, or again, are both lots going to have to comply with the zoning ordinance in entirety?
Yeah, so whenever there's a subdivision of land, we look at how that subdivision might affect compliance with the zoning ordinance. And so, for example, if you have half of a lot that's fully paved and half of a lot that's not, and you subdivide it such that the fully paved area ends up in its own lot, that's going to be it might go from something that complies to something that doesn't comply, and it's our standard practice to require subdivisions to come into conformance with the zoning ordinance. That's a requirement in subdivision law, that all subdivisions have to comply with zoning. So whenever you're doing a subdivision, you gotta either bring all the lots into compliance individually or seek zoning relief. And certainly when you develop the lots, they would need to come into compliance.
Okay.
Per the regulations that we've talked about tonight.
Thank you. And then my last question touches upon the 700 square feet per unit. There is a building typology, this missing middle, where because of IBC code requirements, you can have 4 units per floor, and with 1 stair, which is a relatively efficient build. And so in R4 and in RP, that's not uncommon. And that equates to, in those zones where you can have 45 feet of height, 4 stories, that's up to 16 units. It's very similar to the project that we are doing on Ives, which albeit is a commercial lot, but that archetype could work elsewhere. And if you look at that compared to 700 per dwelling unit, which would take a 5,000 square foot lot and reduce it to 7 units, it's over a 65% reduction in density. And I don't know if that was the intent or not, but it is very, very significant. And I wonder if maybe it would make more sense to have the density restriction for R3 with the special use permit, to have more density there, if that was the intent, or is it to limit the density in R4 and RP?
And I think we'll take that into account, that question. It's a good discussion point. Do you have anything else? Any other comments on these proposed zoning changes?
No, I appreciate all your work on this.
Thank you, Dustin. Next up, former
name.
chair emeritus. I don't know, there's no such thing, but Christine West.
Hi there.
World-renowned architect extraordinaire.
You're too kind. Thanks. I was listening intently. Thank you for all your good work. I know how exacting this can be to kind of scrub the ordinance for strange language, but also very bold and I think full of leadership. So I really applaud the work you're doing and very much supportive of basically all the changes. I just wanted to make 2 points. One, that I do currently serve on the Building Board of Review, and Alexis has been a great staff kind of shepherd through that process. Historically, for the last several years, we have seen a preponderance of, let's call them illegal 3 units that are basically either in R2 zones, but predominantly in R3s, legalized because the city has become more amenable to accepting what this historic triple-decker form has meant. So I think removing the R2 zone removes yet another obstacle, and I think it's in everybody's interest to legalize these 3 families that may be operating as illegal 2s. Once it becomes a pathway to legalize, basically it allows you to expand or modify or upgrade. As everyone knows, there's a lot of unsafe conditions in existing houses, landlords that are flying underneath the radar may not be willing to be upfront about getting building permits. So I think this will, you may not have thought about this, but I think about it a lot. I think by legalizing and making the R2 zones R3, we're going to help ensure a safer pathway. And we are bracing for a flood of R3 kind of conversions because the building code is not in sync with the triple decker kind of model. And there's other work happening at the State Building Code Commission to address that. So that's mostly what I wanted to tell you, is that there's other considerations here besides just simply the density. It's that path towards legalization. I will chime in, and I do think the 700 square foot for the RP and R4 zones is a bit high. As you recall, in 2014, we eliminated a lot of the zoning density restrictions because the inadvertent effect is that people were not able to develop small apartments. And so, you know, we now have a city that is full of smaller apartments, but I do think there's a balance in regulating density there. And I don't know that only demanding super large units is the best. I personally prefer more of a market-based approach, but understand that there's got to be some guardrails. In any case, I'll leave it there. Everything else looks amazing, and I really appreciate your work.
Thank you, Christine. We always like to hear from experts in the field, and your experience elsewhere is beneficial to us. And we also really appreciate anytime Alexis comes to visit us. She doesn't do it often enough.
Thank you.
Next up, one of my other favorite architects, Zoe Mueller.
Hi there. Thank you so much for the opportunity to comment. My name is Zoe Mueller. I'm a resident in Ward 2, and I'm an urban planner by profession. I wanted to speak, first just generally to commend the work that has been done and the pace at which you're doing it. I think it is quite unusual to see this level of zoning changes being implemented so soon after a comp plan, and that's just that kind of momentum is really critical. And overall, I think these recommendations are excellent. The only thing that I did want to kind of make comment on in terms of sort of looking in particular to the second phase of work is thinking about kind of the future of the R2 zone. I am absolutely supportive of collapsing the current R2 zones into R3 as a way of recognizing that existing density and pattern and giving kind of a pathway for legalization and the levels of density that those is appropriate for those neighborhoods. I do think there's still a role overall for sort of duplex or two-family zoning in the city of Providence. But it would be in locations that currently are not zoned that way, locations that generally are zoned for R1 currently. And so I think that it doesn't necessarily mean that the elimination proposed as under the current set of proposals is at odds with this, but I would encourage the sort of this body to take up a potential reintroduction of a revised or recalibrated R2 district as part of the second round with an eye to calibrating it to match the existing patterns for duplexes that exist currently within R1 districts. So just something to kind of keep in mind for the next set, but I think it's not precluding that option to eliminate the current version at this juncture. And as I mentioned previously, I think that's consistent with the larger goals that were laid out in the comp plan and is a good kind of initial step. I think I'll leave it there.
That's great, thank you. There might be some areas that we can look at that would benefit from that. And if you have any specific areas, feel free to send them to Bob and Choyan. We always like getting your notes. Anyone else who cares to comment on the zoning either in person or in our virtual world? Okay, with that, we'll wrap up the public comment portion of this agenda item. Take it away, Bob.
Yeah, so just
summation.
Yeah, so first of all, our staff report speaks to how these zoning changes are implementing the comprehensive plan. So any action you take, we'd want you to make findings that these are consistent with the comprehensive plan and also the purposes of zoning as you're required to do. So we've talked about some potential changes. I just want to put them on the table for you in case you want to incorporate them. So the first one would be this issue of tree replacement, where it would be a 1-to-1 replacement if the forester finds that the tree needs to be removed because it's dead or dying or hazardous, and a 3-to-1 replacement if for any other reason. Then the changes that I laid out in our slideshow, those were on slides 13 and 14. So we have talked about the row house width in that of maybe I'll just so row house width. Now there has been some additional discussion about row house width. If 14 and if 12 feet and 18 feet makes sense to you, 12 for interior, 18 for end, on a 50-foot wide lot, 2 at 18 is 36 plus 12 is 48. That gets you 3 across a 50-foot wide lot.
Do we ever do halves? Because 18 and a half, 12 and a half, and 18 and a half would be the best, or we could just do 19, 19, and 12 or 13. And then with administrative, you could with the modification.
I mean, I think we're splitting hairs here at some point, but, you know, I'm gonna leave that up to you if you wanna go there. And then there are these other just sort of, you know, kind of, technical language changes, that we talked about on those slides. And then I think the only other question that, you know, has come up that I think, we could continue to debate is this issue of the density in, the R4 zone. So I just wanna, you know, talk about where we've been. We originally started removing density restrictions years ago in the commercial zones, and as the former chair described, the issue was we were trying to be agnostic as to the size of the dwelling units, and if you put a limit on the number of dwelling units, the dwelling units can get bigger, but you can't get more dwelling units, and in a market that is, you know, looking for smaller units, we want to at least be able to accommodate that. So to provide that flexibility, we extended that to the R4 zone. And I think that it was a good experiment, but I also think that it opened the door to some things where maybe it wasn't going to be what we want. And we saw one example that came in front of us that produced a lot of consternation and controversy, where there were units in a basement and then five floors on top of that, where you ended up with, you know, something upwards of 50 units on 8,000 square feet. That's in the realm of, you know, 150 square feet of land area per dwelling unit. I don't know the exact numbers, 130 or something. So I think we realized that we needed to put a number on it. And, you know, what that number is, I think we can debate it. You know, part of this is what is the community character? Part of it is in R4, remember that there was a parking exemption for lots of 10,000 square feet and less. And let's face it, people who don't have parking on site might still be looking to have a car, and they're going to park it on the street. And do we want to, you know, overwhelm our streets? You know, if you put in a 50-unit apartment building in the middle of a you know, 3-family zone, what does that mean for on-street parking for everybody else? So I think there's a balance here between, you know, trying to find opportunities for housing and our community character. Last time we did the comp plan 10 years ago, we said we want that density to be on the commercial corridors in downtown and in our transitioning industrial areas. This time around is different. We're saying that the residential zones are no longer sacrosanct like they were with the last comprehensive plan. But, you know, to what degree you know, are we looking to the residential zones to solve the housing woes? So, you know, 3 units right now in a residential zones, you on 5,000 square feet, you get 3 units plus ADU. That's 4 units. We're suggesting that you could get on the same size lot in R4, 7 units plus ADU. That's 8 units. 15 units on 5,000 square feet. You know, 16 units, 4 stories. You know, I don't know. This is as much of a feel as it is, you know, sort of a gut reaction as it is a technical exercise.
Yeah, 333 seems a bit too much. I mean, too loose. I mean, is 500 a good balance for that? Like 10 units on a normal 5,000 square foot lot?
And keep in mind, anything and modification. 15%.
With design criteria that we're going to come up with.
Correct.
We're gonna need to work on that very
Yes.
quickly. Um. Yeah,
I think if you went to 500, you would be looking at people putting 12-unit buildings
Yeah.
on 5,000 square feet, and I think
that might be a lot.
it's a lot. I don't think it's
It needs to be,
undoable in a well-designed way. I think the example, from a few commission meetings ago where it was somewhere between 40 and 50 units
you know, 100,
is untenable
130 square feet.
Right.
Yeah, that was kind of the extreme that we never thought about when we took away the density. Yeah, I mean, I'm definitely, as far as row houses, I mean, that feels more compatible to me with every zone they're going to be fitting in, so I have no issue with 18, 12, and 18 for row house width. As opposed to what we were even proposing for the less, for the 16 and 22. I do think that row houses in R4 should have a lower lot area also, as opposed to the R3. The way the language is drafted, R1 is 5,000, R2 is
R3.
Sorry. R3 is 1667, and so the same with R4 and RP. I'd be okay with like 700 square feet of lot area for that.
I think the
Because-
reality of that, though, is it will be hard to achieve. I agree, just because we should be even, I
Yeah.
think, between multifamily and row houses, but the reality of other limitations on row houses, I think means they will have more
They
lot
might.
area. Unless we get rid of parking.
We get rid
Well,
of-
but we have in R4
R4 has no
Oh,
parking.
I see, yeah.
for
So-
lots of that size. That would
Under
be
10,000 square
a
feet.
700 square foot lot in R4 is at 12 feet wide. I'm sorry. Was it 14, were we saying?
I think we
18,
said
12,
18.
and 8.
All right, yeah, 700 divided by 12 is 58 feet deep.
So you could have
You could have a rear yard.
a rear
Yeah.
yard. I think we're looking for density, but we're also looking for good design, and I think row houses is a way to meet both.
So then row houses in R3 are required to have parking, but not in R4 currently, how it's written.
R4 lots of 10,000 square feet or less are exempt from parking.
But you could also take that R4 lot and build a multifamily with whatever we say we're gonna end up with that
Right,
lot
yeah.
area, there's whether it's 700 feet or 500 square feet. Which, the modeling of that probably means there's gonna be multifamily built there
Mhm.
instead of row houses, because would it make sense to do that? I mean, maybe if you're able to build a few houses and not have to do fire suppression and all of the things you'd have to do in a multifamily building, but that's also looking to be changed as well.
Right.
Everything else in the trees, I'm in favor of as well, as we discussed. All the changes that were proposed in the slides 13 and 14. 18, 12, and 18. The row house land area of 700 square feet, and then R4. All other areas, I'm open to 700 or 500. I think we're gonna have to see what happens. It's just like when we took away the density, we have to start somewhere. And then we'll see what we get. What are your thoughts, commissioners?
Yeah, I'd like to see
the square footage for the row houses come down, in R4, because it's just not gonna make sense for any builder to build them, so they'll never get built, if we have that.
Yeah, I know.
I think it would be simple math for them to simply continue to build multifamilies. But otherwise, yeah, I agree. I like the 12 and 18. I think 12 feet does work. And the tree replacement, I think is a great idea, so.
So the 18, 12, and 18 would be for R3, R4, and RP, right? That's what we'd be discussing.
Yes.
But the only thing that we identify is the minimum width, right? Wouldn't minimum required width?
Yeah.
Minimum required width. That's what these 18, 12, and 18 would be related to.
Because of two corner lots and one.
You're gonna need a side yard on either.
Two end units and then any number of internal units.
Yeah, and my only question with that is, are we considering that the walls, dividing walls have a width as well?
It's usually measured halfway through that wall, that party wall.
Yeah.
And so we'd lose a foot of width in the middle apartment.
You would.
Yeah.
Yeah.
So we're down to 11 feet wide, unit.
Would you like to? Please do.
As your legal counsel, I don't have expertise in urban planning or anything of the like, and my opinion does not count. What I did want to remind this commission is that zoning, when you're setting compliance standards for zoning, this is what I tell the planning department, there's always going to be someone who is looking for relief from the zoning regulations that the city council passes with your recommendation. I just want to remind this commission that the standards for obtaining dimensional variance have been loosened by the General Assembly. So I just want you to keep that in mind, that you're not always going to get applicants who are aiming for zoning compliance. So I just want you to keep that in mind, that for every zoning compliant project, there's going to be another that is aiming for reduction or relief from your dimensional regulations. And so I don't really think of the smallest lot size that's that a development is eligible for as the actual smallest size that will be developed. So I just wanted you to keep that in mind, especially in light of the reduced amount showing that is required for an applicant to obtain dimensional relief.
That's fair. But I still think in an R3 zone, 3 row houses on a normal 5,000 square foot lot makes sense by right, like that. That would be the 18, 12, and 18 that we're talking about. So if someone wants to push the envelope and ask for relief from that, then that's outside of the normal box. But I think if you're looking at a 3-family up or a 3-family this way, it's the same density, and it's actually probably better density in some regards, because you're looking at potentially separate lots with separate owners, owner occupied, and the like.
And just to clarify, my comments were not specific to row houses, more just dimensional regulations generally.
Wonderful.
And I'll just remind you that 15% modification is being utilized a lot.
Everywhere.
A lot. So all of these numbers, just think about 85% I think is just a good thing to keep in mind.
Just a note about single family attached, that we are, this is actually somewhat important, that housing stock is designed to be owner occupied. Okay, so we're talking about number of units and density, but these are very different buildings that we're building here. Single family attached row houses are, by kind of definition, that's a single family house able to be financed through FHA as a single family attached house, not a condo. Okay, you own the land, fee simple. So me personally, I would be more favorable to be more aggressive with those lot sizes to help facilitate home ownership. That's I believe the intended use of a row house is owner occupied, ADU great too, but I just want to make sure, as we're using some of these terms, what we're thinking about where this could kind of go. So the builder of a row house would be a speculative builder, okay, selling those units would be my expectation, versus a multifamily developer would be an owner occupant. Condos are harder smaller condo developments are harder to, finance, harder to sell, harder to, to make work. So just a thought, as we're thinking about where the incentives to these go, my feeling is row houses should be incentivized for potential homeownership.
Generally, owner occupied tend to keep the character of the neighborhood intact as opposed to more transient. What are your thoughts, Bob? You're a consummate planning professional, and I take your advice to heart.
I feel like, it's time for a vote.
You're tired.
And keep in mind that this is a recommendation to the city council. This is gonna go to the council, and we're gonna have these same kinds of discussions there. And I think that, what you're talking about and what is in this document really advances what's in the comp plan. This is where, kind of the rubber meets the road. And I think that, it sounds like we've got consensus on the tree replacement, the miscellaneous text changes, 12 and 18 feet for row houses. I think that seems like a solid number for R3, R4, or RP. Lot size for R4 down to 700 square feet. Sure. I mean, I think there's a practical point at which you can't go any smaller. You probably can't go any smaller than that, so.
To make that for R4 all inclusively, R4 and RP includes all inclusive of row houses and multifamily.
Well, I was just gonna say multifamily lot size, if you wanted to go down to 500, just keep in mind that the number's really 85% of that.
Which is, Alexis, you probably know this by heart. Because you do everything 85% of.
It's 425.
Yeah, so I'm fine with that.
I mean, so what that means, if you take a 5,000 square foot lot, divide by 425, you're gonna get just short of 12 units, but you're gonna get 12 with the ADU, so that's what we should expect.
So it'd be potentially up to like 13 habitable units, the ADU being the 13. 12.
5,000 divided by 425 is 11.
11, round down to
12.
round down to 11, so it'll be 12 with ADU.
12 with the ADU.
Yep, on 5,000.
Which I don't think is, I think
that's not
could be
offensive.
fine.
Yeah, I mean. Gotta start somewhere.
If that's your recommendation.
I'm good with that. I think that meets the intent of the comprehensive plan and the, all of these proposed zoning changes, are in accordance with the comprehensive plan's goals. All the text changes, all of the density, everything we see here today. And I think with all of these changes included,
I'll make a motion to describe it for me.
Recommend.
Recommendation to the city council.
Yeah, approval of these proposed zoning changes based on the testimony and the consistency with the newly adopted comprehensive plan. Inclusive of slides 13, 14, and the last changes we just discussed of the row house width, the R4 and RP land area for row houses, R4 land area, and the trees. That sound?
Yep.
That incorporates it. Okay, so we have a motion. Do we have a second?
Second.
We have a second. We'll go around and do a vote. Noel.
Aye.
Will.
Aye.
Dave.
Aye.
Sid.
Aye.
Charlotte.
Aye.
Miguel.
Aye.
And I vote aye. That's it. I get a motion to adjourn and a happy new year.
Motion to adjourn.
Do we have a second?
Second.
All right, adjourned. Thank you, everyone.
Thank you,
Have a great new
everybody.
year. We'll see you next year. And let's continue this trend of 7 people at a meeting. That would be great.